chair.
Yeah, we have to
You
adjourn the
think
meeting.
next month, Thanksgiving.
You get here and then it'll happen. Yeah. Unbelievable.
Today's meeting of the Municipal Code Enforcement Board is called to order on October 22nd, 2025. Please rise for the Pledge of Allegiance. I pledge allegiance to the flag
of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Please be seated. Agendas of today's meeting are on the wall at the entrance to the chambers. Please remember to turn off your cell phones. The Municipal Code Board consists of 7 members who are appointed by the City Council. We serve voluntarily. It is the board's intention to promote, protect, and improve the health, safety, and welfare of the citizens of Clearwater by providing this equitable, effective, and inexpensive method for enforcing certain codes within the city. The board considers new business in 2 parts. First, the violation, and then the affirmative relief. Formal rules of evidence do not apply. Each side is limited to 15 minutes. The board may grant additional times. All proceedings will be conducted in a calm, civil manner. Individuals who conduct themselves otherwise will be asked to leave. If necessary, they will be escorted from the chambers. Now I ask all who plan to speak, please rise and be sworn in by the clerk.
Do you swear or promise to tell the truth throughout your entire testimony?
Our first order of business is to review and approve the minutes of the last month's meeting. May I have a motion to approve the minutes?
Motion to approve.
A second?
Second.
All in favor?
Aye.
Minutes are approved. Is there anyone here to speak on items not on the agenda today? Thank you. Page turning. Let's move on to new business items. Case number 114-25, Cleveland Street, 639 Land Trust at 639 Cleveland Street. Violation of door and window openings. Mr. Cashman, you have the floor.
Thank you. Good afternoon, Board. Daniel Casman, Code Enforcement Inspector for the City of Clearwater. This is case number 114-25 for 639 Cleveland Street. There was one violation here for Code Section 3-1502, C1, C3, and C4 for door and window openings, window maintenance, windows not facing the right-of-way. These are the dates the notice of violation was sent out with the compliance date. Did receive the certified mailback, and I am in contact with the owners of the property. This is 639 Cleveland Street. This was back in June. They had boarded up during the storms last year, but the boards have been staying in the building for a bit too long at this point. I went back in July, and the boards were still over the windows. Went back in August, they were still in the windows. And then today, they've removed some of the boards. I believe they will be replacing the glass soon. I know there are probably more ideas for what they want to do with this building, but in the meantime, all we're asking is it looks decent while they still plan that out. So, compliance met for the doors and windows by removing all plywood and wood panels from door and window openings, repairing broken windows and doors. And for requesting compliance on or before November 22nd, 2025, or a fine of $150 per day per violation for each day the violation continues to exist.
Is there anyone here to speak on this? No. Board?
When did you last talk with the owner or property manager?
There was a talk with the property manager about a week ago or so, and then they sent me a photo, I believe either yesterday or this morning, of those boards coming off. Again, kind of the same issue with other properties in Cleveland Street that had boards over windows. We just want them looking decent while they are fallow, waiting for their final form.
Okay. All right. Thank you.
Yes.
Have a motion?
I move to find the respondent in violation of the code as referred to in the affidavit in this case.
Second.
All in favor?
Aye. I move to enter an order requiring the respondent to correct the violations on or before November 22nd, was it?
Yeah.
All right. If the respondent does not comply by that date, then the board may order a fine of $150 per day per violation for each day each violation continues to exist. If fines and fees remain unpaid 3 months after such lien is filed, the city is authorized to foreclose, collect, or settle such lien.
Do I have a second?
Second.
All in favor? Aye. Motion passes. Mr. Casman, you're up again.
Thank you.
Case number 115-25, Maria and George Ackerman at 832 Narcissus Avenue in violation of code for fences and walls.
Good afternoon again, Board. Daniel Kasman, Code Enforcement Inspector for the City of Clearwater. This is case number 115-25 for 832 Narcissus Avenue. There's one violation here for Code Section 3-808, A1 through 6 for fence maintenance. These are the dates and notices of violation were sent out with compliance date. I had to post the property, and I did have to post it for today's hearing. I have never been in any contact with the owners of the property. This was 832 Narcissus back in June. It came as a complaint from the neighbors about the grass being tall and a tree had fallen on a fence on the side of the property. This is a better look at that. All that scraggly branches you see to your right is the tree that's fallen forward onto the fence. And this is it crushing that fence. This was in August. There were still issues with the property. This was the affidavit posting because I had not gotten any contact from the owners. I went back after the compliance date in September. The issue was still happening, and this was posting in October for today's hearing. And the tree was removed. Another inspector had a lot clearing case on it, had the grounds maintained, had the tree removed, but the fence is still crushed on that side of the home. And today, it was in the same exact shape. So compliance met for fence maintenance by repairing the fence or removing the damaged section. And I'm requesting compliance on or before November 22nd, or a fine of $150 per day for each day the violation continues to exist.
And I was remiss. Is there anybody here to speak on this case? Okay, just want to skip that part.
Yes.
Board?
No communication from the owner? or
Still
with the
haven't
owner?
tried to get in contact with me.
Okay, thanks. I move to find the respondent in violation of the code as referred to in the affidavit in this case. Second?
Second. A second. All in favor?
Aye.
Motion passes.
I move to enter an order requiring the respondent to correct the violations on or before November 22nd, 2025. If the respondent does not comply by that date, the board may order a fine of $150 per day per violation for each day each violation continues to exist. If fines and fees remain unpaid 3 months after such lien is filed, the city is authorized to foreclose, collect, or settle such lien.
Second.
All in favor?
Aye.
Motion passes.
Thank you very much, Board.
Thank
Case
you.
number 116-25 has been withdrawn, so case 117-25, refined respondent Cadita LLC at 1421 High Street, in violation of code for short-term rental. Anybody here to speak on that case? Could you please come forward and introduce yourself? If you could state your name and come to the microphone once he's ready and state your name for the clerk.
Just give me 1 second.
Thank you. If you could state your name.
Good afternoon. My name is Caroline Degwa,
Okay, your address?
1834 Allendale Drive, Clearwater, Florida, 33760.
Thank you. We're going to hear from the inspector real quick, and then we're going to have you come back up and listen to you as well. So, thank you.
Can we find out what her relationship is?
Oh, yes. What was, sorry, back to the mic. Relationship to the property?
Here representing the property.
Back up just a little bit. There you go.
There you go.
Representing the property.
Okay.
As,
As part owner of the LLC.
Oh, as
Is
part
that
owner
what-
of the LLC?
Yes.
Thank you.
Is that what
Okay,
you're
you're on the
looking for?
LLC. Thank you. Okay.
Thank you.
Yeah, thank you. Appreciate that.
Okay, good afternoon, Board. John Stevens, Code Compliance Inspector for the City of Clearwater. This is case number 117-25 regarding 1421 Pine Street here within the city. We have one violation here for an illegal short-term rental that was being ran. Notice of violation was posted and mailed on July 29th with a compliance date of August the 12th, and we received a certified mail back on August the 15th as signed for. This is an actual Google map photo of the property so we can match it up with what was on the Airbnb, but that is 1421 Pine. Here is the initial listing that I found back on July 29th, and you can see here there was a minimum stay that you could do for at least 3 days, when our code requires that you have to do 31 days or longer or 1 calendar month as a minimum. And this is some of the posting photos from the actual Airbnb. If you click like on the rest of the photos, you can scroll down through it and see what they have there. So it matched that up with the actual property itself. This was on August the 13th here after the compliance date, and the listing actually changed to a minimum of 20 nights, but not all the way up to at least 1 calendar month as we require. On September the 30th, it did finally change to 30 days. So it came into compliance at that point. And then as you see here checking today, it shows now that you can get it for 10 nights. So I think at some point they came into compliance and it looks like they potentially went back out of compliance. So compliance can be met for illegal short-term rental by changing any rental listing on any website or platform such as Airbnb, VRBO, Booking.com, etc., to a minimum of 31 days or 1 calendar month. They can delete the listing altogether and rent the property on a monthly or yearly basis. They just can't do the short term. And then we are requesting compliance by November 5th of 2025 or a fine of $250 a day for the short-term rental violation for each day that violation continues to exist.
Thank you. And I'm remiss, I need to call her back up again. Can you come back for a second? Do you admit or deny? this?
So can I just go back a little bit on the time frame?
First, we have to know if you admit or deny the violation. Did the violation happen?
In those dates that he's representing? No.
So you're denying it?
Yes, because it was changed to 30 days on May 13th, 2025. I reached out to Airbnb to understand why. I'm assuming he's John. I'm assuming why the dates were being inadvertently being changed in their website to not show the 30 days, and they couldn't really explain the details behind it. So I did request a letter from them notating when the dates were changed to a minimum of 30 days. Not 31 days, but 30 days. And that date was effective May 13th, 2025.
You can put the letter on the sheet there if you want so we can see it.
Okay, that's Airbnb.
Board, any questions?
Not yet, I may. Yeah, I have a couple for
For the inspector?
for the inspector first, for Mr. Stevens first.
We're going to switch you out again.
You want to leave the letter up here or?
I don't think we
I
need
don't-
it
I don't
anymore. We've all read it.
see it anyway.
Yeah.
Slide it so I can get to the microphone. Thank you.
May I? Mr. Stevens, the listing that you showed, I didn't quite catch the date where you said you were looking at a listing
Go
that showed.
backwards. Or easier to do it this way. So the initial listing started on July 29th, and you can clearly see on there that it was a 3-day minimum stay.
Okay, if I can interrupt you, I'm sorry, is that Airbnb?
Yes, this is the Airbnb website. Let me
Okay.
go back to the full view here so you can see that. So yes, that's Airbnb's website right there for the property. And you see minimum stay 3 nights right there where I have it highlighted.
All right, do you have a date on when that was, does that have
Yeah,
a date
that's
on?
the day I took that, is down here in the corner, was on 7/29, is the day I took that screenshot from my computer screen.
July 29th?
Thank you. All right,
And then on August 13th, this next photo here is the one where it went to 20 nights. And then on September 3rd was when it showed 30 nights. And then today, when I checked it this morning, it is showing 10 nights. And what I found in going through there when I was dealing with this is certain months, it's set for 30 days. Other months, if there's already a partial listing, then you can still rent it for the 10 days, which means there's a partial listing that's less than 31 days.
Okay, thank you.
So July and August out of compliance and then today.
I can't say exactly how long it's been out of compliance just because I think it is switching back and forth. Or
Yeah.
it has that appearance that it's switching back and forth.
Okay.
Please. Sorry, tell me your first name again.
I'm sorry?
Tell me your first name again.
Caroline.
Caroline, thank you. I'm
Yes.
sorry I didn't write that down. Obviously, the letter that you have
Right.
versus the website displays that Mr. Stevens has,
Correct.
there's a conflict there. Do you have any?
Correct.
And they're in conflict with the letter that you've provided.
Correct.
Do you have any idea what that's about or what occurred there?
I believe I spoke to John as well on a phone call, because I don't understand how that's happening, right? When I had a discussion with him, he said he was going in there changing dates to see, and that's why he was probably getting the discrepancy in the minimum number of dates or nights being available to book. And then after that conversation, I then called Airbnb to understand what he was saying, right? There was somebody in the background going in and changing the dates at their facility, and they said, no, it has to be done by the property owner, the person who is managing the property. So, in all honesty, I have no idea.
Okay.
The first letter that I did receive was back, I believe, in May 12th, and then I called the city to discuss the letter, and that's when they said you need the minimum compliance is exactly what was stated, and then you also need a license to do that.
Right.
So from May 13th, I went ahead and changed the dates to a minimum of 30 days, not 31, 30, and then I went ahead and applied for a license to be in compliance.
Okay.
So, in my opinion, that's my opinion, those dates have always been 30 days.
Got you. Okay.
But you applied in May, but yet in
Correct.
July and August, it wasn't.
That based on.
When was the last time you actually called and found out? Did you check even today before you came here?
I'm sorry, repeat the question again?
Did you call the site that's handling the rental?
Right.
When was the last time you talked with them?
This letter, I spoke to them on September 22nd.
No, I'm not talking about letter, I'm talking
Right.
about phone call.
To Airbnb?
Mhm.
September the 22nd, sir.
September, okay.
Correct. The same day I had a conversation with Mr. Lyle over at Airbnb. This is a follow-up phone call from my discussion after John. That's when I said, then we need something in writing so I can present it to everybody, so I can show when the date was stated as 30 days. And that's why he emailed this letter to me, showing the same.
I'll make a comment. It would appear that despite her best efforts and her communication, that something's afoot in terms of the listing, that it appears that if it's listed, if that listing is not correct, then it's not correct. And it's, during the period that Mr. Stevens noted, it was not correct in terms of compliance with the code enforcement.
Have you had any rentals during the last 6 months?
I'm sorry, sir, repeat the question?
Have you had any rentals during the last 6 months?
For a minimum of 30 days, yes.
Have you had any less than 30 days?
No.
If you get one for less than 30 days, do you have the ability to cancel it or to deny it? Is that part of the system or not?
It's not, right? So if anybody's going into the Airbnb website and they're looking for 10 days, this property right here will not show up as available for 10 days, right? So I'm not gonna get any notification to either approve or decline unless they send an inquiry to me, right? So if they send an inquiry, they say, hey, can you reduce the amount of time from 30 to 10? That's where I can go back and say no
Okay.
through the platform.
Board?
But I
Anybody else?
don't rent outside the platform, because renting outside the platform means I'll have to do a legal agreement to cover most of the terms and conditions, which is tedious.
Well, I thank you for your clarifications, and we'll have a board discussion.
I have a question for Inspector Stevens. Do you have any indication or proof that the property's been rented for less than 30 days in the last, say, couple months?
Our code doesn't require that you have to prove that it was actually rented. Our code says if it's just merely advertised to the public that it's
Okay.
available that way, then you're in violation.
Okay.
Doesn't matter if you actually rent it or not.
Thank you.
Thank you.
Can
That
I
helps.
add to that? There's a little bit more nuance, but what it says is that if you're advertising, that creates the presumption that you are not using it for residential purposes anymore. So, if we get evidence that, but those things are hard for us to prove, that, people are coming and going. A lot of times, we rely on the neighbors to gather that kind of evidence. But the code does say that if you're advertising for less than 30 days, there's a presumption that that's not residential use of the property anymore. So that's why we show you the ads, we rely on that. Doesn't necessarily mean that we wouldn't tell you if we had information that it was being rented. But like I said, it's difficult to get that stuff.
Like you say, it's an assumption that it's being rented, if it's advertised for less than 30 days.
Well, I don't like the word assumption. The code uses the word prima facie evidence.
Oh, okay.
And so that's what we call a legal presumption that something is happening. If you see this, then we presume that it means this.
But going back to Mr. Stevens,
Thank you.
if it's, I'm sorry, I made a step on you. If it's advertised, that's the violation. Anybody else? I move to find that the respondent in violation of the code is referred to in the affidavit in this case.
Do we have a second?
Second.
All in favor?
Aye.
Aye.
I move to enter an order requiring the respondent to correct the violations on or before November 5th. If the respondent does not comply by that date, the board may order a fine of $250 per day per violation for each day each violation continues to exist. If fines and fees remain unpaid 3 months after such lien is filed, the city is authorized to foreclose, collect, or settle such lien.
Second?
Second.
All in favor?
Aye.
Aye. Motion passes. Thank you for your time. Case number 120-25, final respondents Jessica L. Fox at 634 Bellevue Boulevard in violation of code for short-term rental and residential rental business tax receipt.
Board, this one, we're actually just seeking a declaration of violation
Okay.
on both violations in that case.
May I have a declaration?
Is this the first motion?
No, it's a declaration. It's
Mr. Chair, I don't know if there's anybody here to speak on this, but we would, I think, hear for them before that motion, right?
I think there is somebody.
It's a declaration. Do we need to hear?
I'll read
They,
it.
they still have the opportunity to speak if they so choose.
Is there anybody here to speak on this case? If you'd come forward.
They comply prior to me.
Yeah.
Okay, I got you, okay.
How are you today? Okay. If you could state your name and address to the microphone when you, Mr. Stevens.
Hello, my name is Bismira Signari. I live at 2920 Mingo Drive, Land O'Lakes, Florida.
And how are you attached to the property?
Oh, I will spell it for you. Besmira, last name Sinjari. You're welcome.
And how are you connected to the property?
I manage it with my husband.
You manage it, okay.
Uh-huh.
You're here for 634 Bellevue?
No, I am here for 305 South Lincoln. I think that's what
Oh.
we're talking
different case.
That's what was on the board.
No, that's what I was
That's the
pulling
next
for the
issue.
next
Oh, I'm
case.
sorry, I just.
Yeah, 'cause I knew
That's all
one
right.
was-
Now we know who you are.
We'll see,
Okay.
we'll see you in a minute.
That makes sense.
We'll see you, have a seat, we'll see you in a minute.
What do you say? Okay.
So we can go with the declaration then, I think.
I'll be glad to read that.
Go for it.
Certainly.
I move to find the respondent was in violation of the code as referred to in the affidavit in this case. The violation was corrected prior to today's hearing and to enter an order that no fine be imposed. If the respondent repeats the violation, the board may order a fine of up to $500 for each day the violation continues to exist.
Second.
All in favor?
Aye.
Motion passes. So that was Bellevue. So,
And do you need the young lady back up so you can have the whole admit deny
Might as well.
discussion?
Yeah.
yes, if you can come back up.
Yes,
And this is case number 121-25,
correct.
Rudin Sinjari at 305 South Lincoln Avenue.
Yes.
This is your case. Do you admit or deny the violation?
I admit that.
You admit the violation? Okay. So we're going to have Mr. Stevens speak on it first, then we'll have you come back up and tell us your side as well.
Okay.
Thank you very much.
Do we do a?
We should go ahead and do the first motion now.
I believe so.
Yeah.
All right.
Okay, board. Here we go again.
Excuse me,
John
Mr.
Stevens, Code
Stevens.
Compliance Inspector for the City of Clearwater.
Mr. Stevens, excuse me, let me do my motion. Let me do the motion and then we'll
Sorry about
proceed.
that.
Thanks. I move to find the respondent in violation of the code as referred to in the affidavit in this case.
Second.
All in favor?
Aye.
Motion passes. Mr. Stevens?
Thank you.
Okay, so we'll do a brief overview of this one again. John Stevens, Code Compliance Inspector for the City of Clearwater, case number 121-25, 305 South Lincoln. We have two violations here. It was for a legal short-term rental, which we're asking a declaration of violation for later in the recommendation, and then not having a residential rental business tax receipt. This case started back in July of this year. A courtesy letter was actually sent in June. When it didn't come in compliance, had to go and post the property and had a compliance date of July 31st. Here's the posting for today's hearing. That was on October 7th. And this is actually a picture of the property. It's a duplex listed as 305 and 307 South Lincoln Avenue. The 305 is your primary address. And then this is the Airbnb listing that was found back in June that started all this, where you can see that I have highlighted here that you could get it for a minimum of 4 nights. And the reason I highlighted this box here, there was another listing that I found that just showed that it was the correct address. It actually had an address tied to the listing, which is up here is 307 South Lincoln Avenue, which is the other half of that duplex. But you can see the furniture, wall art, all that is exactly the same that was in the previous listing. So this is on August the 13th after the compliance date, and you can see I can do a reservation for 9 nights here where it's highlighted. And then if we fast forward all the way to today, the property owner has brought it into compliance. A couple times I checked it, it has been changed over to the 31-day minimum listing, which is right here, but they have never obtained their residential rental BTR for whatever reason. So this is back in June, showing our list of either permits and things of that nature, cases that we've had code compliance-wise on this property throughout the years. And you can see the very top name is the current owner's name, and the only thing that we have is from 2024. The only other BTR that's been there was from back in 2005. It's not the same person, and it's out of business. It wasn't. It was for a rental, but that doesn't transfer over. So we look at July 24th, same thing. Only my 2 cases are the only 2 new things that were added to that. They didn't apply for a BTR then. And same thing after the compliance date on August 13th. And then today's date, there's still no application for a residential rental business tax receipt. So compliance can be met for the residential rental business tax receipt by obtaining a residential rental business tax receipt, or they have to stop leasing the property at that point. And there's currently still the Airbnb listing that's there. It's just now for the 31 days, which is correct. So our recommendations for the case, for the illegal short-term rental, we're seeking a declaration of violation. And then for the residential rental business tax receipt, we're requesting compliance by November 5th of this year, or a fine of $50 a day for every day that violation continues to exist.
Thank you. Come back forward for a minute.
I paid the BTR fees on the website. Unfortunately, I don't have it with me. But I thought that we had paid that fee. However, I will apply again and go through the channels and get that corrected.
And you'll be fine. If you're in compliance by November 5th, you're fine. So
Yeah,
that's-
we paid the fee on the Clearwater website, the City of Clearwater website. I can find proof of it in my emails, and if I haven't, then I will go ahead and
Yeah,
do that.
just update Mr. Stevens with that after the fact.
Sounds
I was
good.
gonna say, correct me if I'm wrong, but you and your husband own multiple rental properties, right?
No, that's our only one.
Is that the only one? I
Yes.
thought you guys also have one over on Cleveland.
No, that's not us.
Okay. I may be mistaken. I may be thinking another case on that.
Yeah. Okay. No, that's
Okay,
us.
well, thank you very much.
Thank you.
Can we get the declaration first?
I'll move to find the respondent was in violation of the code as referred to in the affidavit in this case. The violation was corrected prior to today's hearing, and to enter an order that no fine be imposed. If the respondent repeats the violation, however, the board may order a fine up to $500 for each day the violation continues to exist.
Do we have a second?
Second.
All in favor?
Aye.
That motion passes. So we got
Somebody
a
else want
second,
to take a turn?
second motion on the other part?
I guess not. All right, regarding the BTR, I move to find the respondent in violation of the code as referred to in the affidavit in this case. I move to enter an order requiring the respondent to correct the violations on or before November 5th,
Yeah.
2025. What's the fine amount for that?
$50 a day.
$50. Okay, if the respondent does not comply by that date, the board may order a fine of $50 per day per violation for each day each violation continues to exist. If fines and fees remain unpaid 3 months after such lien is filed, the city is authorized to foreclose, collect, or settle such lien.
Second.
All in favor?
Aye.
Aye. Thank you.
Thank you, board.
Thank you very much for your time. Case number 122-25, find respondents William Joseph Reese at, did I skip one? No, I didn't skip one.
Nope.
At 1390 South Hillcrest Avenue in violation for code for short-term rental and residential BTR.
Anyone present?
Anybody present on this case? Hillcrest?
Nope.
Nobody present? Thank you.
Guess not.
Thank you.
Okay. Good afternoon, Board. John Stevens, Code Compliance Inspector for the City of Clearwater. Case number 122-25 for 1390 South Hillcrest Avenue. This is another case of an illegal short-term rental that we're going to ask for a declaration of violation on, and then a residential rental business tax receipt violation. This case, courtesy letter was sent out in July of this year, July 9th actually, but I had to go and post the property on August 11th because it remained in violation afterwards. Compliance date was August 17th. This is the actual property itself, and you can see I've got a little circle right here. That's actually the posting of the violation because we did not get a green card back when it was sent out. And then this other picture here is the posting of today's hearing on October the 7th. And then this is our listing in July 9th of the actual property. You can see the center picture up here is the same house that I had the pictures of the posting on. And this is where I was able to do a 2-night pending reservation for that. So they had it set for, normally when you click on Airbnb, if it has a minimum set, when you click on the date, it'll pop up and tell you this is what the minimum is set to. If there's not one, it doesn't pop up. So you have to go to the next page, like choose your actual dates, and then figure out if you can do it that way. So this one, I was able to get it down as low as 2 nights. And then they changed that listing shortly afterwards, so they must have gotten the paperwork, I'm assuming, because it changed to a minimum of 30 nights, and it has stayed at the minimum of 30 nights, because this is actually from today that I took a screenshot from Airbnb. I have not had any contact with this owner, so I'm not sure why they haven't gotten their BTR, but here's, again, a picture of our not our website, but our database system that we use to do our cases, and you can see they've never had a business tax receipt on this property. after the compliance date. Still, the only thing that came in, new cases, are my 2 cases that were added to that, and this will be in the same system. And then here is today's screenshot of that same system, and again, there's no application or issuance of a residential rental business tax receipt. So compliance can be met for the residential rental business tax receipt violation by obtaining a residential rental business tax receipt or stop leasing the property. And again, so for the 2 violations, our recommendation for the illegal short-term rental is we're seeking that declaration of violation. And then for the business tax receipt, we're asking for compliance by November 5th of this year, or a fine of $50 a day for each day that violation continues to exist.
Thank you. Can I get a declaration?
Declaration of violation.
Yes.
Mr. Engel, you want to do a declaration of violation?
Sure, I'll do it again. I move to find the respondent was in violation of the code as referred to in the affidavit in this case. The violation was corrected prior to today's hearing and to enter an order that no fine be imposed. If the respondent repeats the violation, the board may order a fine of up to $500 for each day the violation continues to exist.
Have a second?
Second.
All in favor?
Aye.
Motion passes. Can we have a first and second on the other?
I move to find the respondent in violation of the code as referred to in the affidavit in this case.
Second.
All in favor?
Aye. I move to enter an order requiring the respondent to correct the violations on or before November 5th, 2025. If the respondent does not comply by that date, the board may order a fine of $50 per day per violation for each day each violation continues to exist. If fines and fees remain unpaid 3 months after such lien is filed, the city is authorized to foreclose, collect, or settle such lien.
Second?
Second.
All in favor?
Aye.
Aye. Motion passes. Thank you.
Thank you, board.
Case number 123-25, find respondent Elizabeth Plumley at 1367 South Michigan Avenue in violation of short-term rental and residential business tax receipt. Is there anybody here to speak on that? No. It's all yours, Mr. Stevens.
Yeah, I'm surprised on that one. Okay. Good afternoon, board. Again, John Stevens, Code Compliance Inspector, City of Clearwater. Case number 123-25 for 1367 South Michigan Avenue. 2 violations here for illegal short-term rental and a not having a residential rental business tax receipt. This started back in July of this year when a courtesy letter was sent that did not get any momentum whatsoever in getting anything changed. So I posted and mailed a notice of violation to the property on August 11th with a compliance date on August 17th. This is actually 1367 right here, the picture you're looking at, and I have my actual posting right here of those violations. And then this is a Google Map posting of this. The owners were notified of today's hearing. As I was going to post the property, they were actually at the property and they came out and they talked to me. And I've actually talked to them multiple times over the phone about the issue going on here. They disagree with what the city code requires of them and don't feel that that's fair is the best way that I can put it. But regardless, I thought they'd be here today and they're not.
We're here. We stepped out with a baby. I'm sorry.
Okay.
Okay?
Yeah.
Can you come up and
Yeah.
give your name and address for the
Yes.
record? And then we're going to send you back to your seats.
Okay. Sorry about that. I'm Elizabeth Plumley. I'm the homeowner, and we admit to previously using it as an Airbnb, but we should be in compliance now from our understanding, and that's what we were kind of having issues with.
Okay,
So.
thank you.
Okay, thank you.
We'll call you back up in a minute. Thank you, though.
Okay, I'll continue on. This was on July 9th. You can see here I was able to select a minimum of 3 stays, 3-night stay, because that's what they had it set at. And then this is our Acela system that shows that the last BTR for this property was back in 2019, but you can see the ownership changed. I'm assuming this 54th Ave must have been an LLC, and now Ms. Plumley up here is the owner of the property. This was on August 11th when the property was posted. I could still get it for the 3 nights. Again, there was no BTR obtained at that point. And then this was after the compliance date. I could still get it for the 3 nights. And again, no BTR had been obtained.
Can I
And
ask you-
then, this was on September the 19th, it was still showing 3 nights. And then as today, it's still showing that I can select it for 3 days. And then in that time frame, as of today, she's applied for her residential rental BTR, but she actually hasn't paid the required fee. So she submitted an application, they processed it and said, you're approved, just pay your fee, and she hasn't paid the fee yet, so it actually hasn't been issued. So technically, she does not have her residential rental business tax receipt at this point.
Thank you.
Did you say that as of today's date, that the listing has been corrected, or no?
No, it has not. It's still showing you can do 3 nights. If we go back a page.
And that listing is what? Airbnb again?
Airbnb right here. See, it's still showing 3 nights, and that was as of this morning at almost 9 a.m., 8:58.
Okay.
So compliance can be met for the illegal short-term rental by obviously changing any rental listing on any website or platform such as Airbnb, VRBO, Booking.com, etc., to a minimum of 31 days or 1 calendar month. Delete the listing altogether and rent the property through some other, means on a monthly or yearly basis. They have to stay away from short-term. And then compliance can be met for the residential business tax receipt by actually obtaining it. So she just needs to pay the $31.50 fee, and she'll be good on that portion of it. So our recommendations for this case is for the illegal short-term rental, we want compliance by November 5th of this year, or a fine of $250 a day for every day that violation continues to exist. Same compliance date for the residential rental business tax receipt, but that fine would be $50 a day for every day that violation continues to exist.
Thank you. Ms. Plumley, can you come forward again, please?
Yes, so we submitted the business tax ID request, and then it didn't have a payment portal, but we can take care of that. I think it just is an email, or like how to do that, because we do get.
Should have been sent an email that said basically like, congratulations, it's going to be issued, but it should have gave you a link to go online and actually pay for it.
Okay, we didn't see that. I can definitely look again. On my perspective, so we keep setting the Airbnb app to 31 days. When we kind of talked to him, we went back and forth, and we're saying the issue was we didn't understand because we live in the front house, the back house is an ADU. And we thought because we're homestead exempt, that there was an exception to, the residential codes, and that we could rent it, because most of the year, I'd say over 60% of the year, we use it for friends, family, relatives. We're not exclusively running a business out of the back, like we put the baby back there and childcare and stuff like that. So when we talked to Mr. Stevens, he explained that there's no exemption for homestead, and then we kind of were trying to look at other options and change it to come into compliance. So while it did take us a while, from our understanding, we are in compliance on the listing, because we have no one booked, no bookings, no short bookings. Like when you put in, can I show you just a screen, like from the camera thing? So when you put this in, it literally shows us, like, this is just my phone as the owner. We put minimum nights 31, maximum nights 90, but it's still letting people select fewer days, but when you actually try to book, it will not allow you to.
No, we actually got a booking about a couple weeks ago.
What's your name?
Oh, Wally Maju, this is my husband, but I'm the owner. It's in my maiden name, Plumley.
Just need his name.
Oh, okay.
I'm sorry, Lori, what?
Maju, same exact as her, MAHGOUB as a boy.
So I think the previous woman who was talking about her listing, that Airbnb may be trying to push rentals or like give you the shorter allowances. Like we're trying to come into compliance. Don't have any bookings. I plan to use it as a 30-day. I may even long-term rent it. So we may end up having to just delete this rather than, I'm not gonna, let it go crazy. So I do plan on paying the $31. I'm sorry, I thought that was already paid for. But yeah, we're just, living in the house. That's why we sent a letter to planning and development on 8/30/25 to kind of ask and inquire, but it got returned to us, as I have the mail here if you want to see that. We were trying to just kind of say, hey, we're homestead you know, this is mixed-use property. We have a dental clinic on our street. You know, I don't know if anyone's familiar with South Michigan or off of South Missouri. There's a lot of like businesses there as well, but it's still zoned as residential, so we needed to clarify that. So this was what the actual letter I sent, trying to get in touch with Mr. Stevens at the time. This is a primary residence. We're not investors. We're not trying to violate code intentionally, but there was some communication issues there on our part, and Mr. Stevens did clarify, as he said, in our multiple interactions, and so now we're, you know, intentions to be in compliance, whether that's just paying the bill and speaking to Airbnb again, because when we talked to them, they said it is set at 31 days. So we called them, they said it's set at 31 days. I don't have any bookings. If you see on the app, you can kind of see where people are booked or the calendar dates are blocked, and it's all available. The house is open if anyone was to go there. You know, we're using it for personal use right now, so we don't want to not be in compliance or escalate this any further, so our goal is to remedy that situation. But yeah, we just kind of had that confusion of like, we're homeowners, we just want to use our home at our own discretion, you know, and it's convenient for us not to have long periods of time where we can't access part of our property. So that was, you know, just our personal thing, but I understand the code is the code, so we don't want to, you know, cause any issues.
Thank you very much for your time.
Yeah, thank you.
I'm sorry, I have a question for you.
Yes.
Do you now understand what you need to do to get into compliance?
Yes, pay the $31 and make sure the app doesn't allow anyone to book, so I may need to reach out to Airbnb and have another conversation with them. Or
Great.
I can delete it.
Or delete it.
Because I'm gonna
Yeah.
possibly put a renter in there, and then I would just delete it.
You could delete it, and you may even want to, you know, think about using a different like app like Booking.com or something like that.
Zillow or
Airbnb
something.
is starting to have problems with their thing, which the last lady and you were the first two that I've had anybody complain that they hadn't been able to change it to 31 days and then it magically changed back or whatnot. So I don't know, they could be having an issue. I can't say that they're not, but.
Yeah, 'cause we don't
you may
even
wanna
log
think
in.
about another platform.
Yeah, we don't even log every day, and then it'll say, it hasn't showed us any short-term rentals, so it should be, as far as we know, we're just not getting any bookings at the 31 day mark. But from what I can do on my side, I've set it as that, so, you know, I'm not intentionally not being in compliance from that point of view.
You do understand there is no homestead zone.
Yes, and he said in a street that's in a different area, you can do like a bed and breakfast thing if you live on the property, but that's not my zone. So there's no exemption. So that was why some of the delay. I was just explaining, like, I was trying to clarify and say, oh, we thought we could do this and here's why, because we're on the property, we're overseeing it. We're not like just renting out the house to anybody and having big parties, but, you know, now I understand that fully, so.
Thank you very much for your time.
Thank you.
Thank you.
We thought we had some property rights.
Yeah.
Well, you do, not when you go with Airbnb, you know,
Yeah.
It's just
it
different.
doesn't apply.
Yeah.
Thank you.
Thank you.
Thank you.
Can we revisit the declarations that you're looking for?
Yes, so, declaration of, actually, this one was a full, for on both of them. So
Okay.
if they, you know, get it changed and everything like that,
Yeah.
within the timeframe, it'll be
It's not
fine.
showing up.
So-
Yeah.
Oh, you need the page back up?
If you don't
No,
mind.
I just wanted to be sure what it was, what we're going
Yeah.
to declare on, or ask for a violation on. Anybody else?
No? Anybody else want to do this declaration?
Regarding the short-term rental, I move to find the respondent in violation of the code as referred to in the affidavit in this case.
Do you have a second?
Second.
All in favor?
Aye. I move to enter an order requiring the respondent to correct the violations on or before November 5th. If the respondent does not comply by that date, the board may order a fine of $250 per day per violation for each day each violation continues to exist. If fines and fees remain unpaid 3 months after such lien is filed, the city is authorized to foreclose, collect, or settle such lien.
My second? All in favor?
Aye.
Thank you very much for that.
Regarding the business tax receipt, I move to find the respondent in violation of the code as referred to in the affidavit in this case.
Do we have a second? All in favor?
Aye. I move to enter an order requiring the respondent to correct the violations on or before November 5th. If the respondent does not comply by that date, the board may order a fine of $50 per day per violation for each day each violation continues to exist. If fines and fees remain unpaid 3 months after such lien is filed, the city is authorized to foreclose, collect, or settle such lien.
Do you have a second?
Second.
All in favor?
Aye.
Thank you, Board.
Thank you. Case number 124-25, find respondents Jose Luis Medina Malula and Vivian Medina and Claudia Michelle Medina at
Please.
1321 South Evergreen Avenue in violation of code for short-term rental and residential business tax receipt. Is there anybody here to speak on that? You could come forward and give your name and address.
Good afternoon, Claudia Medina. The address is 1321 South Evergreen Avenue, Clearwater 33756.
Do you admit or deny this?
Admit.
You admit, okay. Do you have a seat for a minute, and then we'll call you back up?
All right, this is my last one, Board, I promise. Case number 124-25, 1321 South Evergreen. Again, my name's John Stevens, Code Compliance Inspector for the City of Clearwater. 2 violations here for the residential rental, business tax receipt, and illegal short-term rental. This started back in July as well with a courtesy letter that there was no response to, and I posted the property, which you can see here in the picture, on August 11th with a compliance date of August 17th. This was the initial listing in July, and you can see that I have highlighted here that you could get this as low as 2 nights. And in checking our system, they did not have any type of residential or business tax receipt. There was actually some type of case that happened in 2019, but it's a different owner's name regarding a BTR, so the property must have got sold and transferred. This is the listing actually on August 11th, the day that I posted it, and I could still get it for 2 nights. And again, no BTR was applied for during that time frame, just my 2 cases that have been added to the list there. This was on August the 13th after the compliance date, and it's still 2 nights, and no BTR had been obtained. And excuse me, that was actually August 18th. I apologize on that, not the 13th for that follow-up. And then today, in checking it, it was still showing 2 nights, and there's still not a business tax receipt. The young lady that just came up here, she actually called me earlier today, and we spoke on the phone, and I'll let her tell, her side of it, what's going on, but basically, she says she is going to get everything in order. So compliance can be met for the illegal short-term rental, and is by changing any rental listing or any website or platform such as Airbnb, VRBO, Booking.com, etc., to a minimum of 31 days or 1 calendar month, delete the listing altogether, and rent the property on a normal monthly or yearly basis. And then for the business tax receipt, they obviously has to obtain that business tax receipt or stop leasing the property. And then our recommendations on this is we'd like both violations to be in compliance by November 5th, 2025, or a fine of $250 a day for the illegal short-term rental, or a fine of $50 a day for the business tax receipt for each day those violations continue to exist.
Thank you. Can we go ahead and get the first violation? We should get that out of the way first, though.
Before she?
She already admitted the violation, so we'll
All right.
get the first one out.
Move to find the respondent in violation of the code as referred to in the affidavit in this case.
Do we have a second?
Second.
All in favor?
Aye.
You can come back up.
Yes.
Thank you.
Good afternoon.
Ma-
So,
Excuse me, are you Claudia or Vivian?
I'm Claudia.
Claudia, thank you.
Yes. So after speaking to Mr. John, I finally called Airbnb, and I do have the site set up for the 31 days. I didn't know until I spoke to John and Nicole that that was the code. So I did go ahead and correct it. I could show you guys the website now. Also, after we got the notice on August 13th with the picture of the notice on the door, we have been using the property ourselves. We did buy this as a primary for my father's retirement home. He's coming from San Francisco, but he wasn't here full time, so we just thought that this would be like a fun idea. We didn't realize that there were so many codes and so many things. We just saw a fun Facebook ad or video saying you could rent your house part-time. Since August, we have been at the property. When Mr. John came to deliver the letter in person, we were there, we saw him in person. I do have the app now, which I put here, set up when I called Airbnb as well, saying that we can no longer rent for 31 days or less. Okay, there we go. 31 days or less. So I'm not trying to be out of compliance. We are trying to do what we need to do to get everything up to code. So far, this was the only step I could do. I did go into the system to try to pull the tax ID out in case we do decide to do this later on in the future. I was not able to successfully complete it. John has also given me a phone number to help, for somebody to help me get through it so that I can get that in code in case we do decide that we are going to rent it later on in the future. But as of right now, it is a primary residence. I did go ahead and change that as well.
Mr. Medina, have you applied for your BTR?
I tried to apply for the BTR. I'm not sure if you can see that we're in the system, but it was asking me for some sort of like LLC licensing, so that's where we got stuck. And I have somebody's phone number that's going to walk us through it to get us all the way through the entire application. But I got delayed there once it started asking because I said we don't have a license. This was just supposed to be a part-time kind of like a fun thing while we're not at the property full-time. So no, I have tried, but I don't have it fully completed, no.
Okay. Well, Mr. Stevens can probably help guide you through that.
Yes, which he has. He's
Okay.
given me information, which I'll be contacting them later on this week.
All right, thank you.
Okay?
Thank you.
I have a question for you.
Yes.
Were you in the audience when Mr. Stevens made the comment about, based on previous cases we've heard today, that Airbnb may be, potentially may be, making changes to short-term rental availability?
Yes.
Okay.
I have, and I spoke to him earlier this morning. There was a couple of bookings, which we just got started on this a few months ago. I don't even know, we're in October. Maybe, I think we closed on the house in March. We lived in it till June or July, I think till July. And then my father said, I'm gonna retire towards the end of the year, and then I'll come out. So I said, oh, well, this is fun. Let's just rent a little bit, and we'll help us with the mortgage. So we didn't get too crazy into it because we didn't get too many bookings. I think we got it like right at the end of the summer. So Airbnb we just put up some pictures and put a description up, but they have been changing their stuff. When I called them to let them know that we could no longer do it for a short term, I think they try to push dates on you or try to do incentivizes. But yes, I have heard, and I am aware. But we're gonna have to figure out if we do decide something, maybe change it up, or like I just heard him say bookings.com, or maybe something different if we try to do
Okay.
31 days or more.
Great.
But we're moving into the property, so who knows, maybe later on in the future.
A learning curve, yeah.
I'm sorry?
A learning process, yeah.
Very, yes, but it is what it is. And again, we don't want to be out of compliance, I'm here, so I'm hoping that I have somebody to walk me through the license, the tax ID part of it, which is I
Yeah.
think the BTR is what you said?
BTR.
Yes, the BTR, I'll have it just in case. And then, as of right now, I've corrected then the Airbnb, so it's no longer under 31 days,
Thank you.
okay?
Thank you.
Thank you.
guys.
Do we have a second motion?
Second, I move to enter an order requiring the respondent to correct the violations only before November the 5th. If the respondent does not comply by that date, the board may order a fine of $250 per day per violation for each day each violation continues to exist. If fines and fees remain unpaid 3 months after such lien is filed, the city is authorized to foreclose, collect, or settle such lien.
Second.
All in favor?
Aye.
Motion passes?
And we need another motion on the,
Yeah, on the BTR.
Okay.
Yeah, I moved to find the respondent in violation of the case as referred to in the affidavit in this case.
Do we have a second?
Second.
All in favor?
Aye.
Motion
Mr.
passes.
Chairman, I move to enter an order requiring the respondent to correct the violations on or before November the 5th. If the respondent does not comply by that date, the board may order a fine of $50 per day per violation for each day each violation continues to exist. If fines and fees remain unpaid 3 months after such lien is filed, the city is authorized to foreclose, collect, or settle such lien.
Second?
Second.
All in favor?
Aye.
Motion passes. Thank you.
Thank you, board.
Case number 4.12 and 4.13 are continued till November. Case 4.14, which is case number
Thank you, John.
127-25. Find respondents Jeffrey Fowler at 1 022 Iroquois Street, violation of for permits and issue and order compliance. Is there anybody here to speak on that case? Please, sir, if you would please come forward.
Which case are we on? 127.25 dash 414.
Okay.
Jeffrey Thaler, live at 1808 Sherwood Circle, Clearwater, Florida, and I'm the owner of 1022 Iroquois Street.
Do you admit or deny the violation?
I deny it.
You deny the
It's in
violation?
compliance, yes.
Okay, if you can have a seat, and we'll call you right back up.
There you go. Slow, okay.
I'm slow.
Can you all hear me good? I know I'm much shorter than everybody else.
You're good.
Okay. Good afternoon, Code Board. I am Catherine Rees, Code Inspector for the City of Clearwater. This is in reference to 1022 Iroquois Street, case number 12725. The number of violations is 1, permit required in section 4-203A1. No person shall commence any construction, demolition, modification, or renovation of a building or a structure without first obtaining a building permit, specifically structural and electrical on this case. There were multiple notices of violations because there were previous inspectors involved and then myself. So I basically started from scratch on the same case with the notice of violations. The first, with the compliance date of August 8th, 2025. And this was the posting for a hearing. And here are the pictures of the work that was done. These were taken by the previous code inspector, which does show flooring, drywall, ceiling joists, more drywall, electrical, again, more joists, more electrical. And that's also flooring there. More electrical, more drywall. And then we have this, which would be structural, with the wood. It's bricks that were coming off, but also the wood paneling in it behind that.
So everything's being remodeled?
Pretty much, from the pictures, yes. Compliance can be met by obtaining and completing a permit. Recommendation for this case, requesting compliance by obtaining a permit on and before November 24th, 2025, and completing the permit on or before April 24th, 2026. If the violation continues to exist, impose a fine of $150 per day, each day that the violation continues to exist. And that's it.
So if you want to come back forward and.
Since it took them 8 years to bring me here, can I get an 8-year extension? I'm just joking.
Well, it sounds
Don't
good.
hold your breath.
A permit was already pulled on Monday, so that's been done already. They'll be coming out hopefully Friday to finish the permit, so it'll be completed and we'll finish up by then.
Okay.
If you want to see the permit, I got it with me.
Yes, please.
If you don't mind, put it in the projector.
Let's leave that there for a second. Can we zoom in on the upper heading, Nicole? Or does it automatically just do that? Okay, there we
That's
go,
better,
1022
yeah.
Iroquois, okay.
Building, electric.
And
I requested one for the kitchen, and they told me since the kitchen cabinets were replaced, they didn't move any of the plumbing or electrical for the kitchen, you didn't need one for the kitchen cabinets. Because originally when I spoke, was it you I spoke to once before? I spoke to somebody once before, and they said they wanted the kitchen, electrical, and drywall. Then when I went down and spoke to them, they said, no, you just need drywall and electrical.
So you permitted just for those two, the building and
And electrical, yes,
Okay.
correct. Because they have all the pictures already down on building,
so you did an owner-builder permit, okay.
yes.
Thank you for bringing that. That
Yeah.
helps,
Yeah.
Yeah.
Yeah, I made lots of copies too, because some people say you gotta give everybody a copy. I didn't know you had this nice simple system here that you just lay it
We're
down and
high-tech.
everybody
We're
reads it. Yeah, we're
high-tech,
high-tech here in Clearwater.
Any other
I'm
questions,
looking,
Boyd?
no, I'm just looking for a date on that, and I don't see a date on it, but
You know,
it's,
the date-
I mean, it's a permit. It's
I
just,
don't
oh, there it
know.
is, issued 10/20/25, so 2 days ago.
Yeah, 2 days ago,
Yeah,
yeah.
I'll look into that.
I don't have my glasses on, so I can't
No,
see it.
yeah, I get it. Okay, thank you for that.
You're welcome.
Any other questions, Boyd?
Session 1:10:25.
You want to go ahead and have a seat? Well,
Okay,
thank you for your time.
thank you.
Do you have a motion?
Were there any other questions? No?
You want to take the motion?
Is it going to be a declaration, or is it going
It's going to be a first and second
First,
motion.
first and second?
Yeah.
I move to find the respondent in violation of the code as referred to in the affidavit in this case.
You have a second?
Second?
All in favor?
Aye.
I move to enter an order requiring the respondent to correct the violations on or before 11/24.
Yes.
If the respondent does not comply by that date, the board may order a fine of $150 per day per violation for each day each violation continues to exist. If fines and fees remain unpaid 3 months after such lien is filed, the city is authorized to foreclose, collect, or settle such lien.
Second.
All in favor?
Aye.
Aye. Motion passes. Thank you.
Thank you.
Thank you for your time, too, as well.
Thank you, sir.
That means I need to return again, even though I already have a permit?
No.
Yeah, as long as you just work with your inspector and make sure everything's.
Yeah, just stay in touch with, sure.
Well, he has a
So let
compliance.
Yeah.
He has a compliance.
I'm happy to work with you. I do. Do you mind if I go grab him one?
No, go ahead, yeah.
Yes.
I was gonna say we can move on, but it's okay.
Thank you, sir.
Okay, thank you. Case number 128-25, finding respondents, Caroline Windows and Doors LLC at 1165 Eldridge Street in violation of code for permits and issue an order. Is there anybody here to speak on that? Yes, sir. Okay, if you can come and state your name and address and affiliation.
Hi, my name is Clint Morrell. I'm an attorney with Becker and Polyakov. We represent Caroli Windows and Doors LLC. My address is 3909 West Empedrado Street, Tampa, Florida, 33629.
And does your client admit or deny the claim?
We admit that there were modifications to the fence without a permit.
Okay. You'll have a seat for a second, and we'll play back up.
Hey, good afternoon, Board. My name is Catherine Reese, Code Inspector for the City of Clearwater. This is reference 1165 Eldridge Street, case number 12825. This also will be for one violation for permits required, section 4-203.A.1. No person shall commence any construction, demolition, modification, or renovations of a building or structure without first obtaining a building permit. Specifically for this case, it will be for the fence. Again, I did give multiple notice of violations, since this is a very old case as well. With a compliance date of August 8th, 2025, I did get us certified from the previous inspector assigned green card on 10/22 of 2019, and I also did post the property on 10/8 of 2025. So just to give you some reference here, this is where the business is located, which would be just east of South MLK. And I believe this is the train tracks right here. I'm not sure. This is a posting for the hearing. So I know you may want me to go back and forth a lot on these pictures, so just raise your hand if you want me to flip back and forth, okay? This is a Google photo from 2019. This is the side that faces Eldridge Street. And this is a Google photo from 2025, same side. And these are pictures, I've highlighted all the new posts that you can clearly tell from the Google photos that have clearly changed, as well as the bollards that were installed. And those are the bollards as well on Eldridge. This side is the side on Missouri Avenue from 2019. This is the side of Missouri Avenue in 2025, also showing a new post. So yes, there has been maintenance on a lot of this side, but the changing of posts does require a permit. This is just a little angle that you could see from Eldridge. This would be Maple Street side in 2009. They didn't have anything, earlier than that to show. And this is from 2022. So again, there's bollards on that side as well, 2 different sets of them. And this is the front of the property, right where their entrance is on Eldridge. And this is all these pictures here are from today. And keep in mind, this photo here, as you can see, they have a keypad. I did get to witness that they are electrical, so it opens automatically. Same as that one.
Sorry, can I query that? You mentioned electrical, or I'm not sure what it is that you're communicating about that, whether there's electrical
That there's
required.
a clear change, complete change to the fence. It's beyond maintenance, is my point.
Okay. Are you inferring or saying that electrical was added or electrical was done?
Yes, it was
performed as-
manual gates back in
Oh, okay. So it was
2019.
changed from manual to electrical.
Right.
So there's
So if I-
electrical
Correct.
work involved.
Right.
Okay, all right. Thank you for that.
No problem. And there you can see again another keypad and the tracks down on the ground there. Compliance can be met by obtaining and completing a permit. This is for violations permits required, requesting compliance on or before November 24th to obtain a permit, and completing the permit on or before April 24th. Correction on that, it is 2026. Sorry about that. If the violation continues to exist, impose a fine of $150 per day each day that the violation continues to exist. Do you wanna come
Thank you.
back?
Yeah, if you want to come back forward.
Mr. Clint?
Thank you for your time. So this fence has been in place, a chain link fence has been in place at the property for quite some time. Upon receiving these notices, my client believed that the fence was grandfathered. I've since communicated with Ms. Reese and explained that due to the modifications that have been made, there needs to be a permit application, so that permit will be applied for. There is going to need to be a survey obtained of the property. So I would request a little bit more additional time than 30 days, perhaps 60 days, but there is an intent to bring the property into compliance.
Thank you. Board, questions?
Comment based on experience, survey will be required, but I'm good with 60 days.
All right.
Fine with me, yeah.
Mr. Chair, if I may, I think the recommendation was
Yeah.
far greater than that. Did you,
What was
your deadline
permit
recommendation?
For obtaining the permit itself, because I don't want to not include the completion of a permit, because then we go through this vicious cycle of people
Right.
obtaining permits, not getting final inspections. So the completion date, I am asking of April 24th of 2026.
Well, I mean, the work is already done, there may have to be, based on code, there may have to be some changes made, but that's
Right. This will
that's
be an
next
after the
year.
fact.
It says requesting compliance on or before November 24th. That's, a
That's
month
to
and
obtain
2
it.
days from now.
Just to get the permit, though, just to get the permit.
Right, right. But in order to get the permit,
You need the survey.
you've got the survey and then the application and the approval and issuance. So that I can understand why the owner's representative is asking for 60 days. It's not unreasonable to
Okay.
me.
Board has spoken.
Anybody else?
We don't have an objection to that,
I
right?
do not have an
We're-
objection.
we don't have
I'm sorry.
I'm sorry.
I should have asked.
Additional time to get the permit. Just to clarify, that to complete the permit, there's
Yeah.
additional time for
Yes.
that as well.
Do we have a motion?
I move to find the respondent in violation of the code as referred to in the affidavit in this case.
Do we have a second?
Second.
All in favor?
Aye.
I move to enter an order requiring the respondent to correct the violations on or before, what's the date? And you want 30 days on top of that? December 24th?
It would be December 24th.
December 24th, 2025. If the respondent does not comply by that date, the board may order a fine of $150 per day per violation for each day each violation continues to exist. If fines and fees remain unpaid 3 months after such lien is filed, the city is authorized to foreclose, collect, or settle such lien.
Second.
All in favor?
Aye.
Thank you. Thank you.
Thank you, sir.
Okay, so, case number 129-25 and case number 130-25 are both withdrawn. So we have case 131-25. Find the respondents K at Clearwater Beach Condo Association, 622 Mandalay Avenue, in violation for permits. Is there anyone here to speak on that? Yes, if you could come forward to and give us your name and address and affiliation with the property.
Good afternoon. My name is Susan Kim, 622 Mandalay Avenue, Clearwater Beach, 33767.
Do you admit or deny the violation?
Denied because it has been happened before I purchased that property. It was 6 years ago.
Wow.
And
If you'll have a seat for just a moment, we're going to have you speak, but we'll have you explain it first, and then I'll have you speak in reference to it. Thank you.
Good afternoon, Board. It's Catherine Reese, Code Inspector for the City of Clearwater. This is for 622 Mandalay Avenue, case number 13125. One violation for this property is permits generally, permits required. 4-203.A.1, no person shall commence any construction, demolition, modification, or ratification of a building or structure without first obtaining a building permit. I have given notices, 3 notices for this property with compliance date of 5/20 of 2025. Did have from the previous inspector a signed green card on 4/9 of 2024. And this is a picture of just an aerial shot of the property. This is Mandalay Avenue right here, and this would be Hillwood, to give you a better understanding of the photos. So this is facing Hillwood, and this is the only area that we are questioning today. The rest of this, as you can see, was withdrawn because she did come in compliance. So this.
I'm sorry, could you be more specific about this?
So this whole building, this area here has a 622 Mandalay address, even though it's on Hillwood, because it's connecting to her 620 and 618 going south on Mandalay.
Okay, thank you.
You're welcome. And this is a Google photo in April of 2014 on the Hillwood side and what it used to look like. And this is from March of 2025. This is a picture of the concrete that was laid out to get rid of the divider between the garages. And this is a corner shot from Mandalay to show you the pavers that are there. This is from October 16th, the other day when I went, because I've been there quite a few times for multiple reasons. And this is another picture on the Hillwood side. And this is as of today, as well as this. I know the deck is different. That is permitted, thankfully. So,
Okay, good.
and this is that angle. I also would like to add that I have spoken to Ms. Kim on multiple occasions. She has come into our office, has been explained what is required of her. And she also spoke with Ray Dress, who is our engineer specialist. Because this is the beach, a lot has to be considered, especially the beach by design. If you'd like explanation of that, I will have Mr. Dress come up. That is not my expertise at all. But nonetheless, there are codes for the beach to have a certain amount of landscaping. Compliance can be met by obtaining and completing out a permit or remove pavers and concrete slab and bring it back to its original state. Okay, and this is again for permits required violation, requesting compliance date of obtaining a permit on or before November 24th, 2025, and completion of permit by April 24th, 2026. If the violation continues to exist, impose a fine of $150 per day each day that the violation continues to exist.
Becca?
So I want to solve the problem, and we trying to building permit application, and then denied it because of before we had the email continue with my attorney and Mr. Green, and that if we have a new survey and the ISR form, and we can apply the permit. And we did all prepared, and then we went to the building department, and they denied it because of need a general contractor. And then before, they said to us, without general contractor, if we have new survey and ISR form, and we can do it, we try to save thousands of dollars from contractor. And the contractor, I contacted about 5, 6 of them. They are not interested at all because it's already existing papers on it. So, and then it's hard to find the contractor because they try to get $3,000 or thousands of dollars. But here, the papers, we took it out, the existing papers here and planted it and on the side, and the car is parking on the driveway. And then when people step out of the car, and that they have to step on the dirt, and then nobody wanna, step on the dirt, especially women and the men who have nice shoes, they don't wanna step on it. So it's the pavers, and also I did here this area I did a plant too. And let's see here. So this area is entry area. And the entry area, if you take it out the paper and put the dirt on it, you have to walk on the dirt because from the entry area. So that is, we need to try to get the permit, but contractor, they are not interested in because the paper is already existing and all work done, and so.
So you are in the area what's called beach by design. So there are other rules that you'll have to know to be in compliance with, not just putting pavers over and cement over.
Okay.
So that's going to be a part that you're going to have to sort of navigate through so that you can have people walking there and have plants where you need to have plants.
Yes.
Because
So
it is
it's
beach by
hard,
design as part of it.
right on the front
Otherwise,
area.
that's part of your permit process, and that's why we have permits, so you do the right thing.
This is true, and I might offer too that if she is trying to figure out a solution, she can also meet with the building department in terms of what she can do, what she can't do, so that she can
Yeah.
apply for a permit to find something that will comply, that can be done. As far as your contractor issues, we can't help you with that.
I do appreciate her communication. I do ask, that's really all I ask most of the time. However, this has been going on for quite some time. The process has been explained to her on multiple occasions. I have personally spoken to about 6 different contractors on her behalf so they can have an understanding of what needs to be done. At this point, we just need something solid. I'd like to continue to work with her during the process, whoever she needs to speak to. I'm happy to guide her the right direction, but we just need a solid date to get this in compliance.
Makes sense.
None of the contractors were interested at all that you spoke with?
The ones that I've spoke to said she's better off just removing the pavers, and the last time I spoke to Ms. Kim, that is what she had advised me she was going to do, which we wouldn't be here if that did occur.
Okay, thank you.
Well, that would be one way to get it into compliance. It's the quickest sort out whether,
Yes.
and that if she wants to do something in the
Which
future,
you
she
don't
can
want
do
them
that.
walking on dirt, that's
Right.
the problem.
Well, she can figure out something
I
after
know,
that, but
I was thinking about that.
That's what
Grass.
the primary issue would be compliance,
Yeah.
to avoid the.
Board? We have a motion?
We didn't do a first motion, did we?
No.
No, I move to find the.
You wanna take it? First motion?
Is there a first motion?
Yes.
I move to find the respondent in violation of the code as referred to in the affidavit in this case.
Second.
All in favor?
Aye.
I move to enter an order requiring the respondent to correct the violations on or before 11/24. If the respondent does not comply by that date, the board may order a fine of $150 per day per violation for each day each violation continues to exist. If fines and fees remain unpaid 3 months after such lien is filed, the city is authorized to foreclose, collect, or settle such lien.
Second.
All in favor?
Aye.
Thank you. And if you work with your inspector, you'll find a solution.
Thank you, Ms. Campbell.
Thank you, Ms.
Moving on, case number,
It's old business items now.
continues.
Yeah.
Case number 132-25 is continued.
Yes.
Moving on to old business, which we like old business. Can I lump all the 5.1s together? Okay. Looking for an affidavit of compliance on case 72-24, case 114-24, case 49-25, case 55-25, case 105-25. Can I have an affidavit of compliance?
A motion?
Yes.
I move to accept the affidavits of compliance as listed.
Second.
All in favor?
Aye.
Motion passes. Thank you. Case number 38-25. Accept the affidavits of non-compliance for respondents. Diolo Partners LLC at 39 Turner. I guess we just will accept it. We don't need to see it.
Can you list them all?
Yeah. Do we have an affidavit of non-compliance?
Yeah.
I move. Somebody else want to read?
I'll take it. Affidavit of
I
non-compliance.
move to accept the affidavit of noncompliance and issue an order that imposes fines and states that fines and fees remain unpaid 3 months after such lien is filed. The city is authorized to foreclose, collect, or settle such lien.
Second.
All in favor? Aye. Motion passes. Case number 43-25, accept the affidavits of noncompliance for respondents William R. Black at 2390 Willow Tree Trail for abandoned building. Anybody here to speak on that? Do we have an affidavit for noncompliance? You want to take that one?
Mr. Rick?
Is it this one?
Affidavit of noncompliance?
I move to accept the affidavit of noncompliance and issue an order that imposes fines and states that fines and fees remain unpaid 3 months after such lien is filed. The city is authorized to foreclose, collect, or settle such lien.
We got a second?
Second.
We got a second. All in favor?
Aye.
Motion passes. Case number 52-25, accept the affidavits of noncompliance for respondents Gonzalo Diaz and Selena Diaz at 112 Brownell Street for short-term rental and business tax receipts. Is there anybody here to speak on that? If you could come forward, sir, and state your name and address.
Good afternoon.
My name is Gonzalo Diaz,
And your address?
1122 Brownell Street, Clearwater.
All right, thank you. Do you admit, I guess? Do we still do the admit on this one since it's in compliance?
It's just an affidavit of
Yes,
noncompliance.
his opportunity to.
To explain
Speak.
why.
Yeah. Right now, you're showing a non-compliance with the, is there
Yeah,
anything that's changed?
I just received a letter, this letter, I guess, Mr. Stephen just sent to the property. I received it last Wednesday for the lady who cleaned. I wasn't sure that code exists about short term. I just live far away from here, so I just got a property management who deal with all this. He told me I have to come here with my wife and I don't know, the house, just to let you know, is just for sale since the last 45 days. It's pending right now for the closing on November 19. I wasn't sure once again, about the code for the short term until last Wednesday. I have the proof in here that they sent me the letters and everything. I don't know if they can take a look in here. It was Wednesday, October, and the letter was received once again for the people who cleaned the house, and they sent a screenshot to me, so I don't know if there's anything to add on it, so. Anything else do you need to add?
No, not with the board
Okay.
has any specific questions.
All right.
Okay.
Have you applied for your business tax?
No,
receipt?
I decided to sell the house.
Yeah,
Okay.
November 19th it closes, you said, right?
Yeah, correct, yeah. It's pending right now, it's pending.
Okay.
Is it currently rented?
I'm sorry?
Is it currently rented?
No, not at all. It's good.
So I'm just kind of thinking through this thing.
You can set it for a status if you want. You have your options of whatever you want to do with this one.
Well, this is for short-term rental and BTR, and it's being sold, but if
What
he's
causes-
already in violation, then
You
maybe we
accept
ought to
the
hear from
affidavit
Inspector
of-
Stevens and get some data.
Huh? Yeah, I mean, I would continue it to see, make sure everything is gone and you're, they're in compliance. Because compliance occurs if you no longer have the issue, right?
Right, the next board meeting will be after the,
be
after the sale
9th.
date, so if we continue it to
Yeah.
the next board meeting, we're fine.
You can accept the affidavit of noncompliance at that time if something has changed.
Yeah.
Sounds good to me.
Okay, somebody want to make a motion consistent to that?
I move to forward the date for the affidavit of noncompliance to next month's meeting on, what, 11/24?
Yeah.
25, and revisit it at that time.
We have a second?
It's after Thanksgiving.
Do we have a second?
Second?
Oh, second.
Second.
All in favor?
Aye.
Thank you.
Okay, of course.
That'll happen after you sell it. That happens after you sell it, so you're good.
We're just verifying that it's sold at the next meeting. If it's sold, then they can go ahead and dispose of this.
Oh, will be another meeting.
You'll get another meeting notice, yes.
One more meeting.
But if it's sold, you don't need to.
I
be
will
here.
just pay attention for the letters. So once again, I don't
Yeah.
receive those letters because usually the people who rent.
Yeah,
they
if
get
it's
it.
sold, you don't need to be here, though, I don't think.
Thank you.
I have a question about that, though. I know from experience that the county is very slow in recording new buyer ownership on there, and so when that may not, the
Yeah, we
records
would
may not
need
change
the,
prior to that, so some.
The inspector needs to be in touch
Yeah.
with them and verify
Yeah.
that that has occurred.
Okay.
So you have documentation that we can present you.
Moving on to case number 53-25, accept the affidavits of noncompliance for respondents Clearwater Angler LLC at 607 North Myrtle Avenue for sign maintenance. Anybody here to speak on that? No?
Nobody?
No, so do we go ahead and accept it?
No. I move to accept the affidavit of noncompliance and issue an order that imposes fines and states that fines and fees remain unpaid 3 months after such lien is filed. The city is authorized to foreclose, collect, or settle such lien.
Second.
All in favor?
Aye.
And now we're moving into other board action, 6.1.
Chair, we would like to just move that to after the nuisance abatement lien so that we don't have to have all the inspectors here.
Okay.
Good.
Unless they want to be here.
All right, we're moving now to after the, okay, so case number 160-25, accept the nuisance abatement lien for respondents Michael Pluckett at 205 South San Remo Avenue. Is there anybody here to speak on that?
Hi, Vicki Sedeth with the City of Clearwater Code Compliance Inspector. This is for 205 South San Remo Avenue. This is case number 160-25. There's one violation here for overgrowth, code section 3-1503, B7, B8, B10, and B5A. Notice of violation was posted and mailed on 9/29/25 with a compliance date of 10/9/2025. Certified mail receipt was not received. It was returned unclaimed. This is a picture of the posting on 9/29. It's a picture of the front yard on 9/29. Again, on 10/15/2025, nothing had been done there. And then this morning, at 8 o'clock this morning, it was still overgrown. Compliance can be met for the block clearing by clearing all trash, debris, and overgrowth from the property. Requesting compliance 5 days after the board renders its order.
Any questions?
Inspector, is anyone living there?
I don't think that he is anymore. He's lived there for a long time, but, I have not seen him in several months. And, I mean, I know there's no water or anything in the house, so.
It looks abandoned by the pictures.
Well, there's a lot of cases on it already and
Oh,
unsafe case. It's not even a livable home at this point, but.
I see. Thank you.
Do we have the motion for the nuisance
I'll take
abatement?
I move to enter an order finding the respondent in violation of code and requiring the respondent to correct the violations within 5 days of the board written order. If the respondent does not comply within the time specified, the city may take all reasonable actions, including entry onto the property, to abate and maintain the nuisance and charge the respondent with the reasonable cost, which will become a lien on the property. If costs, fines, and fees remain unpaid 3 months after such lien is filed, the city is authorized to foreclose, collect, or settle such lien.
Second.
We got a second? All in favor?
Aye.
Thank you, motion passes. Case number 161-25, accept the nuisance abatement lien in respondents Kathy Carroll at 1910 Union Street for lot clearing and operative vehicles. Anybody here to speak? Yeah, stop that. Mr. Kasman?
Give it a second. All right. Good afternoon again, Board. Daniel Kasman, Code Enforcement Inspector for the City of Clearwater. This is case number 161-25 for 1910 Union Street. It's a nuisance abatement. There are 2 violations here for Code Section 3-1503 B7 B5 for lot clearing and Code Section 3-1503 B6 for an operative vehicle. These are the dates the notice of violation was sent out with compliance date, and the affidavit posting was done the same day. This is 1910 Union Street. I got a complaint from the neighbor about the rear yard. There's a lot going on there. A lot of overgrowth and a lot of items. An RV showed up with no license plate on the property as well. This is the day of the posting on the 2nd. The RV and they did do a little bit of grass cutting, but there's a lot of stuff hidden in tall grass, engines, washers, dryers, all sorts of stuff. So this was after the compliance date. The property was still in the same shape along with the RV. And then I went by this morning. Some stuff is migrated up front, and the rear still needs some maintenance. So compliance may be met for lot clearing by mowing the lawn and removing all trash and debris from the grounds of the property. Compliance met for the operative vehicle by ensuring all vehicles at the home are roadworthy and registered, or removing all inoperative vehicles from the premises. For this one, we're breaking down into 2 different asks for the recommendation. For the inoperative vehicle, we're asking for compliance on or before November 1st, 2025, or $150 a day fine. And then for the lot clearing, requesting compliance on or before 5 days from the date the board renders its order.
5 days would be,
You don't have
I
to
don't-
state it out, though.
okay.
I don't think you can do the first one.
For
It's a regular, you have to do a regular notice for that.
11/1 is 8 days.
I mean, I'll defer to you guys what you think, because you have to defend it if, if you're,
I'm not sure what the question is.
well, the first one isn't, it's not a normal violation that's come before them with a notice of hearing to be heard. This is done as a nuisance abatement. If you all are comfortable with it, that's fine, but I would think it would go under our normal notice.
Rebecca, Code Compliance Manager. So our interpretation is that it's still a nuisance violation. We're just choosing to impose a fine rather than look to abate.
Okay. It's on the record.
Okay.
Can I have a nuisance abatement?
I mean, I'd have to, I guess, look at the actual notice to see if I agree or disagree, but normally if the counsel for the board is advising against something, then we normally go along with that. We can continue it. I don't know that I necessarily want to move forward with something that he's saying is objectionable. I would rather.
I don't want my board
pull it
doing
back,
something that,
take
you
a look
know,
at it again.
is out of the norm.
Board, should we do a continuance just to
Yes.
give them time?
Just to the first one, not to this, obviously.
Correct.
not to the second.
If there's a question, can we would request that we move forward with the lot clearing and then postpone the in-op.
Yes.
Can I ask a question? I'm confused about what it is you're concerned about.
Well, this is under a nuisance abatement notice as opposed to a regular code violation.
Okay.
So this is not the same kind of notice that we would do under a normal code case. It's not the same procedure.
Okay.
And if I'm the individual, hypothetically, and I'm getting a nuisance abatement notice versus a code violation, one puts me on notice to do one thing, the other puts me on notice to do something else. I may or may not show up, so it's a due process issue.
Okay?
So may I have, what I'd like is a motion for the inoperable of the vehicle to be continued to next month.
I make a motion that the violation of the.
Hang on a second. So, but we're not continuing the nuisance abatement part of it.
No, on the lot clearing, we're not.
In
On the
fact,
vehicle, we are.
what might be simpler is if the city agrees to just withdraw the first one, because it's a fine, versus a abatement, right?
Right, we
So
can
we-
abate the second one.
Right, so
and the
if
other
they
one's gotta
withdraw
come
the
back
first
next
one
week, or next month.
and bring it back, that's fine, when we could just do the second one.
I mean, the other way you could do it is just come back next month,
Right.
get the first one out of the way, and then do the abatement all at once.
I mean, if you want, so if you want this to be abated, that's fine, just can't fine. So if you want to leave it as, and you're asking them to abate a nuisance, that's fine, you're asking them to fine them,
Related to the lot clearing, we can move forward and postpone the in-op.
okay.
So the board order would only be in reference to the lot clearing of the property, not removing an abandoned vehicle from the property.
Do we put a date
Or
on
an
the post?
inoperable, sorry.
Sorry. Do we put a date on the postponement? 30 days?
Nicole?
That's fine.
Nicole,
I'm
do we put
sorry.
a date on the postponement?
We were just talking about that.
Because of my noticing requirements for the other type cases, this wouldn't be able to be heard until December. Because I've already noticed for the November hearing.
So should we just say postpone?
It's got to be renoticed. I would ask the city to just withdraw it,
Right.
and then it's not before you.
Do we make a motion on that, or does the city do that?
If the city withdraws it, then we're
Okay. I
done.
see a
It's
nod.
just a question of whether or not they're going to withdraw it.
So we're asking the city, will you withdraw it?
Yeah, we'll withdraw it, and we'll check the notices, and we'll, you know, if we can renotice and come back next month or in December, then we'll do that. But
That's fine.
we'll double check the notice, the concern is duly noted, and we'll withdraw that.
And we're going to make our motion on the lot clearing.
Yes.
Right, please.
Yes.
Thank you.
All right. I move to enter an order finding the respondent in violation of the code regarding the lot clearing and requiring the respondent to correct the violations within 5 days of the board's written order. If the respondent does not comply within the time specified, the city may take all reasonable actions, including entry onto the property to abate and maintain the nuisance, and charge the respondent with the reasonable costs which will become a lien on the property. If costs, fines, and fees remain unpaid 3 months after such lien is filed, the city is authorized to foreclose, collect, or settle such lien.
May I have a second?
Second.
All in favor?
Aye.
Motion passes. Thank you.
Thank you.
Case number 164-25, accept the nuisance abatement lien for respondents AP Beach Properties LLC at 405 Coronado Drive for lot clearing and issue an order of compliance, deadline, and authorize the city to mitigate compliance.
Did you guys skip 7.3, 1755 Sunset?
Yeah, I did.
Oh, okay.
I did personally. Case number 162-25, accept the nuisance abatement lien for Karen Freese and Daniel Freese at 1755 Sunset Point Road for lot clearing. Thank you.
All right. Good afternoon, Board. Daniel Kasman, Code Enforcement Inspector for the City of Clearwater. It's case number 162-25 for 1755 Sunset Point Road. It's a nuisance abatement. There are 2 violations here for Code Section 3-1503, B7, B8 for lot clearing, Code Section 3-1503, B6 for an operative vehicle. These are the dates the notice of violation was sent out with compliance date and the affidavit of posting. This came as a complaint from neighbors, 1755 Sunset Point. The grass is very high. It's even grown up through the paver driveway. It's overgrown a little bit along the sidewalk as well. Noticed a truck parked in the grass adjacent to the driveway, and the vehicle sticker has been expired for nearly a year. This is the date of the posting, on the 25th of September. Still same issues, overgrown. Hold on. There we go. Give it a second. And then this was from today. I have spoken with the owner. Hopefully we will be able to take care of these issues and we will not have to abate. But
That's kind of ironic that his truck's parked on the grass, but yet he's got pavers for a driveway.
I couldn't speak to the wisdom of it.
I'll tell you why.
All I'm asking is the vehicle displays a current
I'll
tag.
tell you why.
Okay.
Because it's a drive-in, drive-out driveway, and if the truck's on the pavers, you can only go in and back out. You can't do the circular driveway. Okay.
Could be. But, compliance can be met for lot clearing by mowing the lawn / driveway and edging the curb and sidewalk. And compliance can be met for the operative vehicle by ensuring all vehicles in the home are roadworthy and registered, or removing all inoperative vehicles from the premises. Request compliance on or before 5 days from the date the board renders its order, please.
I have a motion.
I move to enter an order finding the respondent in violation of code and requiring the respondent to correct the violations within 5 days of the board's written order. If the respondent does not comply within the time specified, the city may take all reasonable action, including entry onto the property, to abate and maintain the nuisance and charge the respondent with the reasonable costs, which will become a lien on the property. If costs, fines, and fees remain unpaid for 3 months after such lien is filed, the city is authorized to foreclose, collect, or settle such lien.
Second.
Got a second? All in favor?
Aye.
Motion passes.
Thanks for clearing that up.
Now on to the case I wanted to do.
Thank
Case
you.
164-25, accept the nuisance abatement lien for respondents AP Beach Properties LLC at 405 Coronado Drive.
Good afternoon, Board. Kevin Maddox, Clearwater Code Inspector. Let me get to my PowerPoint here. Uh, 405 Coronado Drive nuisance abatement. This is for case number 164-25. Seems to be a little slow.
See the wheel go round and round.
One violation for code section 1503B7, B8, and B period 5A for lot clearing, overgrowth right-of-way, and accumulation of debris and trash. Notice of violation was mailed and posted on 9/25. Compliance date of 10/6. Certified mail was received but unsigned. This is a very large parking lot in the middle of Coronado area. And as you look through here, the main issue is parking, and on the weekends, the complaints from the neighbors is the huge group of beach crowds come through, park, trash is everywhere, and not cleaned up and not maintained at all. There is grass cutting that occurs, but just to the point of making sure there's room enough for people to park. I took pictures from multiple locations and areas, but the large lot makes it difficult to understand how large this is. On this picture here, where you can see my mouse, it is a small section across the street that is connected to this parcel, and originally that's what was brought up in the courtesy notice phase, which I was able to connect with a management company, and they said, yes, we would add this to our next mowing schedule in the next 5 to 7 days. That never happened. The growth, as you can see here, continues just to get deeper. This was approaching the height of the trash cans. Anywhere where it's not easy to mow, it was not taken care of. This is on October 6th, and it continues just to get longer. And this was the 6th as well, getting a little bit longer. On today's date, I went out and I almost can't see the trash can from across the street as the weeds grow up. The maintaining of the curb lines are not taken care of, and the section across the street was not touched. This also shows, looking across this very large parcel, just trash strewn throughout. There are trash cans, some of them are overflowing. Compliance can be met by cutting all grass and vegetation, to include the curb line, sidewalk, and continuing to maintain it, removing all trash and debris, and to continue to keep it clean. Recommendation is compliance 5 days after the board renders its order.
Do we have a motion or questions?
I move to enter an order finding the respondent in violation of code and requiring the respondent to correct the violation within 5 days of the board's written order. If the respondent does not comply within the time specified, the city may take all reasonable actions, including entry onto the property to abate and maintain the nuisance and charge the respondent with the reasonable cost which will become a lien on the property. If costs, fines, and fees remain unpaid 3 months after such lien is filed, the city is authorized to foreclose, collect, or settle such lien.
Second.
All in favor?
Aye.
Motion passes. Thank you. Case number 165-25, accept the nuisance abatement lien for respondents Clearwater Beach BK Investors at 423 Mandalay Avenue for lot clearing in order of issue for complaints.
Good afternoon, Board. Kevin Maddox again, Code Compliance Inspector for City of Clearwater, case number 165-25. It's still slow. One violation for Code Section 1503B5A, accumulation of trash and debris. This was called in by the neighbors. The notice of violation was sent out on the 10th of October, compliance date by the 17th of October. Green card was not received back. It was sent out. This is where the, I don't know how to say this bank, but Truist Bank. I'm from Arizona, so it's not common for me. This is the front of the building. This is where it was posted. The address is on Mandalay, but the posting is where the common entrance to the parking lot and entrance to the bank, which is on the back side, was placed where it could be seen. In the back corner of this parcel and away from the bank, but still on the parcel, the complaint called in that all of these, this trash and pallets are stacking up and continue to stack up and never get addressed, causing rat problems and other pests. It backs up to 3 different businesses from the Mandalay backside, but the parcel belongs to the bank. On the day that I went in, I did notify the bank in person. I got a hold of an assistant manager. I brought her out and I showed her the problem, and that was the last interaction I had with the bank. This was on the 17th. This is the bank, and it continues to still stay in the same state. Today's date, this is the bank, and you can see there's a pallet out here on this back street, as well as the pallets all behind this area and this corner. Compliance can be met by removing all trash and debris to continue to keep it clean, and requesting compliance 5 days after the board renders its order.
Inspector, when you had your interaction with the manager, did she happen to tell you why all those pallets are stacked out there?
I don't think she said, "This is my first day."
It's a dumping ground. It's a dumping
And
ground. Really?
I gave her my card, she gave me her card, and I didn't hear anything after that.
It's a great place for contractors, whoever to dump their pallets and not haul them off.
That's amazing, especially on Mandalay.
Yeah. Well, it's back behind there.
It's on the
you know.
backside, points out.
Yeah, I know that bank over there.
Well, there's, everybody else is dumping there. Why don't we?
Nuisance abatement lien, we ready?
Yeah. Somebody else take a
I
turn.
move to enter an order finding the respondent in violation of code and requiring the respondent to correct the violations within 5 days of the board's written order. If the respondent does not comply within the time specified, the city may take all reasonable actions, including entry onto the property to abate and maintain the nuisance and charge the respondent with the reasonable costs which will become a lien on the property. If costs, fines, and fees remain unpaid 3 months after such lien is filed, the city is authorized to foreclose, collect, or settle such lien.
Do we have a second?
Second.
All in favor?
Aye.
Motion passes. Thank you. Case number 166-25, accept the affidavit F, accept the nuisance abatement lien for respondents Mary Johnson, EST at 950 Lantana Avenue for lot clearing.
Good afternoon, Board. Kevin Maddox, Code Compliance Inspector for the City of Clearwater. This is case number 166-25. Number of violations, one violation for 1503 B7, B8, and B58, overgrowth, right-of-way overgrowth, and accumulation of debris and trash. Notice of violation was mailed and posted on the 15th of September. The compliance date was the 25th of September, which did not happen. The certified mail was received unsigned. This is the lot where it was posted on the 15th, and it's very long. I didn't even need a cone. I'm pretty sure you can see how long that is. On the 25th as well. This is a lot that sits where the house used to be before it was demolished and then left in this state. The 22nd, it remained unchanged, but just a little bit longer, which is today. Compliance can be met for lot clearing by cutting all grass, vegetation, including the curb line, sidewalk, and continuing to maintain it, removing all trash and debris, and continuing to keep it clean. Requesting compliance 5 days after the board renders its order.
Any questions? Nuisance abatement lien, you got it?
I move to enter an order finding the respondent in violation of code and requiring the respondent to correct the violations within 5 days of the board's written order.
Second.
I'm not done yet.
It's a long one. This is the longest one we have.
Interrupting my motion here.
It's a long
If the
one.
respondent does not comply within the time specified, the city may take all reasonable actions, including entry onto the property, to abate and maintain the nuisance and charge the respondent with the reasonable cost, which will become a lien on the property. If cost, fines, and fees remain unpaid 3 months after such lien is filed, the city is authorized to foreclose, collect, or settle such lien.
You done? Second.
All in favor?
Aye.
Motion passes. Now we're moving back to 6.1. Nicole?
Yes, Chair, we have two proposed changes. This is both by staff and the city. The first one is in Article 6, Order of Business. We're recommending that you remove citizens to be heard on items not on the agenda. That's in conformity with what the City Commission is doing, and also, frankly, there's no need for any issue to be brought before you that's not on the agenda. I believe a couple meetings ago, we had someone come up and just rant and rave on something that wasn't relevant to you. You give the opportunity for the public to speak on every matter that comes before you, and those are the only things that are relevant before you. So we recommend that that be removed, if you want to consider that first before we get to the next one, which is a little more detailed.
So what is our action on that to?
Accept the motion. You accept it as you.
Make a motion to remove that citizens to be heard from your rules, and we will take care of that. Renumber your rules of procedure.
Can somebody make a motion to?
I make a motion for the agenda, the historic and typical agenda item of citizens to be heard regarding items not on the agenda be removed for our activity and our meetings.
Do I have a second?
Second.
All in favor?
Aye.
Motion passes.
The second one is under Section 9, and there's actually some additional change to this language since this was printed. But in essence, what this allows the city, because we bring these cases before you for fine reductions, some of these, from a timing perspective, become a little difficult because of when we have your meetings and the notice. This is really allowing the city, when there is a purchase of the real property, to deal directly on the settlement agreements that you've seen before. And with this suggestions of payment of 10% of the outstanding code enforcement fine or $1,500, whichever is greater, in order to satisfy the outstanding code enforcement lien. This can only occur if the new purchaser of the real property has never owned the property, so they're not doing what we call a straw man type of thing, where I sell my property to you, and then you sell it back to me, and I get to be able to reduce my fine by doing that. So that eliminates that issue, that they have to maintain ownership of the property for 12 months, possibly a hold harmless if the city requires it. The additional provision in there is allowing the time period of the 10 days to occur after the closing has occurred, which I believe the closing is within 90 days, right? If the notification, Mr. Simpson can expand on this.
Yeah, thank you. Rebecca and I were discussing this, and really where this comes is somebody's trying to buy the property, closing's quick, short time frames, they need the lien to be settled so they can take over the property and then fix everything. So we want to encourage these transactions just for these properties that are lingering, allow flippers and developers, whoever. We don't really have an interest in that. Our only interest is getting these properties fixed up and improved. So we'd like to be able to have the board just delegate that authority to us if it meets these requirements. And so essentially it's 10% of the lien or $1,500, whichever is greater. So we would always get at least $1,500 to cover our costs for making these cases. And then in the event that it was greater than that, we would get 10%. And then they would have 90 days from the date that it closes to bring everything into compliance. And assuming that happens, we give them notice of compliance. That effectuates the reduction, then they have 10 days from there to make payment. And then that would settle everything out. We bring these stipulation agreements to the board now, but usually, it's a lot slower than what these buyers would like. We'd like to have the flexibility. We also think that with 10%, the board may be inclined to go lower. In fact, you have on many occasions gone lower than 10%. We think that if we give an administrative process to where it's like you don't have to come to the board, you can agree to 10% today, it might incentivize some of these folks to go ahead and pay a little bit more than coming to the board and giving the whole history of what's going on to try to get less than that. Of course, they're always entitled to that still. So if they don't want to pay the 10% because they have a financial hardship or some other reason why they want to go lower, they want to come and make their case, they'd still be allowed to do that. And then the way the council for the board has drafted it, the city also has the discretion to not enter into one of these agreements if for some reason we don't feel like it's appropriate for whatever reason, in which case we would just push these to the board for review, just like any other lien reduction you would see. So that's it. We're just asking for a delegation of the authority to execute these stipulation agreements as long as they are a bona fide purchaser. They are willing to pay 10%, they get it fixed in 90 days, and then they can pay within 10.
And again, you're getting compliance, which
Right.
is your main goal here, and you're not having to deal with the administrative part of it, which the city has to do anyway, and it's kind of a delay.
Yeah.
Even when we bring it before you, we've seen people go, well, when can I pay? Well, we still have to get the order, we have to do this, we have to do that. So this is much quicker and it gets things done. I really think that the part of having to own the property for 12 months avoids people that are trying to flip property to do this.
Agreed. My main question would have to do with, number one was, do they have the option to still have the option to come before the board? You answered that. But I'm reminded of a case I had several years ago as a contractor where an investor was looking at buying a property. They'd got a stop work order, and there'd been fines accruing to the tune of, I think it was $616,000, And so 10% of that is still $61,000. And so you may, in a rare case, have one where the owner wants to close and the buyer wants to close, but they're not going to accept that, So a lower percentage could work in that case, or they could just come before the board. But I think, you know, by and large, with most of them we've seen, it's not a,
Yeah.
it's a no-brainer.
Do we have an agreement to make a motion on this?
So we would never see these cases, then you just enact that?
Assuming that the parties, assuming that the board adopts the rule, that we did, the rule that was presented, that we did, staff requested a friendly amendment to remove the 12-month. That's, I guess, a point of conversation. Still, in terms of what exactly the board would be adopting today. If you could see what's on the highlighter, or what's highlighted on the board there, we're recommending to remove the 12-month requirement and to replace it with bringing the property into compliance within 90 days. From staff perspective, we don't really have a concern if the person lives there or they don't, or if it's just someone flipping the property and trying to make money. We don't really have any concern either way. Our main concern is having them bring the property into compliance within a tight time frame in order to get the reduction.
So can we add that language into this now?
Yes, you could just, the maker of the motion could just say that they accept the amendment suggested by the city.
Well, I have a
Does
question.
that makes sense. I mean, I don't own properties more than 6 months when I flip them, so. And I make them pretty, very pretty.
We don't want to, in fact, we want to encourage people, if the flippers are the ones that are going to fix it,
Yeah.
then that's great. That's what we'd like. So, and if, assuming that the bona fide purchaser would be the person that would be asking for this, assuming that they agree to this, to the 10% and fixing it within 90 days of closing, then it would not come before the board. That's kind of the whole point,
Yeah.
is that we would agree with them, we would enter into a stipulation, we have the authority to do it under the rules, and we sign it, they're off to the races and they can get it fixed.
Streamlines the process.
Right, and if for some reason they don't agree, like for example, they don't want to pay 10% because even still, it's very high, for the example he brought up, then, you know, it just comes to the board just like normal.
Did I hear you say something about brought into compliance within 90 days?
That's what our friendly amendment that
Yes.
we've recommended is essentially within 90 days of the bona fide purchaser closing and taking ownership, they have to have everything in compliance.
Okay.
Then the lien will be reduced. They have 10 days to pay. Once that happens, we file the paperwork and the clerk files the release and the lien goes away. It never comes to the board. If for some reason they don't get into compliance within 90 days, or they do, but then they don't make payment within 10 days, those are issues that we would probably then bring to the board for clarification.
That was my question, because, you know, if you take a couple of cases we've seen back over the years, whether a house is storm damaged and the roof is collapsed, now it's going to have engineered drawings, and then it's going to have to find a contractor, he's going to have to take bids, he's got to pull a permit, and he's got to do all the work. 90 days is not a realistic target. If
Yeah.
that's the case, if it's just coming to the board and they need more time, I'm great.
Yeah, we would just bring those to the board. We're asking for a very limited set of circumstances where we can do it on our own without the board involved.
Gotcha.
So
Okay,
we're looking at passing section 9 with the friendly amendment.
Yes.
So we can have a motion to accept number 9 with a friendly amendment.
I make a motion to accept item number 9 with the friendly amendment.
Do we have a second?
Second.
All in favor?
Aye.
Motion passes. We are adjourned.
Thank you.
You got to hit the gavel. We can't leave unless, there you go. Thank you.
There we go.
I feel much better. Thank you.